Good afternoon, Your Honor. We don't hear you.
You don't hear me?
Now we do. Mr. White is ready.
All right, good afternoon, Mr. White. You ready on Mr. Shoemaker?
Yes, sir, we are.
All right, this is cause number CR 23-74, State versus Christopher Reagan Shoemaker. Motion to adjudicate or vote. Go ahead, Mr. White.
I believe that the court will have before it a motion to withdraw the motion to adjudicate guilt in the state, and we're in agreement with this. Are going to ask the court to place and amend Mr. Shoemaker's probation to have him serve a term at the substance use felony punishment facility.
Okay. All right, Mr. Shoemaker, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, you can lower your hand. All right, Mr. Shoemaker, you heard what your attorney, Mr. White, said. Is that correct?
Yes, sir.
And are you pleased with Mr. White as your attorney?
Yes, sir.
And you understand that if the court grants this and I amend your conditions of community supervision to send you to safety, that I'm going to be expecting that you're going to successfully complete that drug rehab program. You understand that?
Yes, sir.
You understand what happens if you go down there and you get kicked out for lack of effort, lack of participation, or bad behavior or anything else? Do you know what happens?
I'm assuming I signed for time.
Well, whether you sign for it or not, you're going to get it from me.
Yes, sir.
Do you sign for it or not? You understand if you go down there and you don't go down there with good intentions about trying to get help for your addiction and turn your life around, then when you get back, I'll have run out of options. And despite the valiant efforts of Mr. White to convince the prosecutors to give you this and to extend this opportunity to you, despite any efforts of theirs in the future, you're looking at one more stop in your life, and that's not a good one.
Yes, sir.
Are we clear on that?
Yes, sir.
All right. Anything from the state?
Nothing further, Your Honor. Thank you.
All right. Then the court will grant the state's motion to withdraw the motion to revoke. Court will amend the community supervision conditions of Mr. Shoemaker to include completion of the substance abuse felony punishment facility, also known as the SAFE-P. All right, Mr. Shoemaker, it's time to get to work.
Yes, sir.
All right. Thank you. We're adjourned.
Thank you, Your Honor.
Thank you, Mr. White.
Mr. Lowe is ready now on Mr. Gerard.
Okay. Good afternoon, Good afternoon, Mr. Lowe. How are you, sir?
Thank you, sir.
All right, Mr. Gerard, how are you doing, sir?
Doing good. How you doing, sir?
Hey, I'm doing fine. Thank you for asking. You're looking well, my friend.
Thank you.
All right, this is cause number CR 22-67, State versus Robert Gerard. And I think we're just still set on a status. Go ahead, Mr.
So, Your Honor, the psychiatrist, she's just about ready to get her report. She's asking for another week, another 2 weeks. I would say 30 days. And so I think there was a whole lot of information in her file, and our investigator was very helpful in putting that together for us. So we're asking for an additional 30 days. But I will report that Robert's taking his psychiatric medication on a regular basis. No issues with that. It did turn out though he had diabetic coma that happened to him before he went. So he has to take insulin shots 5 times a day now. So that's going well with him. So he's gained a lot of weight. He's healthy and ready to get this resolved.
Did he know that he was a diabetic before that happened?
No, sir.
Really? Wow.
He had to be life-flighted to the hospital.
Goodness. Well, I'm glad that you're well now.
Thank you.
Figured that out. So
yeah, that was scary. When I woke up, I had all kinds of IVs in me. I didn't know what happened.
I could only imagine how scary that would be. Right.
Yes, sir.
Mr. Hartwell, on behalf of the state, do you have any objection to Mr. Lowe's request for additional time?
No objection, Your Honor. Thank you.
Okay, then the court, if you have your schedule there, Mr. Lowe, look at either December 3rd or December 5th. Tell me if one of those works better for you.
The 5th would be better, Your Honor.
The 5th is better for you? Okay, then the court will set Mr. Gerard then for another status of defense expert report. And that will be December 5th at 1:30.
Thank you, Your Honor.
Thank you, sir.
You're welcome. All right, we'll see you gentlemen back on the 5th, and hopefully nothing too exciting will happen in between now and then medically for Mr. Gerard.
Thank you, sir.
You're welcome. You have a good day.
Y'all have a good one too.
How you doing?
I've been good. Thank you. Can we have 4 minutes?
You can have 4 minutes and 29 seconds.
Is Mr. Weiner on Zoom yet?
I do not see Mr. Weiner. No, ma'am.
Because we do not have his lady in here yet.
Who is he here on? I haven't looked
He's
back.
on Warington. He said that he was just gonna make an announcement. So,
Okay, yeah, as soon as I see Mr. Weiner, I'll let you know and we'll bring him in.
okay.
All right, thanks.
Your Honor.
Patty, did you hear me?
No, sir.
So that was the longest 4 minutes I've had in my life.
I know, that's what someone else just told me.
Judge Martin 4 minutes is what that was.
No, that's about twice as long as the Judge Martin 4 minutes.
Yeah.
I'm ready to proceed if you're ready to proceed, Judge.
Who do you want first?
James Bustamante, come on down.
Bustamante. This is cause number CR 21 00009, CR 21 281, State versus James Daniel Bustamante. Mr. Bustamante, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, thank you.
Your Honor, I'm sorry to interrupt. I'm not sure if there's been a finding of competency or if that is still outstanding. I don't mean to interrupt or get out of order, but
Mr. Schmidt, do you want to comment on that?
Judge, I do know that I asked that Mr. Bustamante be evaluated by a psychological professional. He's been evaluated by 2. Both of them have found him competent to stand trial. We do not object to those findings and are prepared to proceed.
All right, thank you, Mr. Schmidt. All right, Mr. Bustamante, are you a United States citizen who reads, writes, and speaks English?
Yes, sir, that's correct.
And have you ever been diagnosed with a mental condition?
Yes, sir, I have.
And are you currently on medication or undergoing treatment for that?
No treatment, sir, just the medications, yes, sir.
Okay. Do you feel like you have a rational understanding of what's going on in court here today?
Yes, sir, I do.
And you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you as your attorney?
Yes, sir, very pleased.
Do you have any questions about the paperwork, your plea agreement, or anything else before we go further?
No, sir, no questions.
All right, Schmidt, believe Mr. Bustamante to be competent here today?
Judge, I do believe he is, as the court is aware, and I brought up previously, I've known Mr. Bustamante for several years, and we've had issues in the past. I've been able to meet with him a couple times up to here, and I feel confident that he understands what's going on.
Okay. And have you also explained to him his rights as they relate to this case and also the advantages and disadvantages of a deferred adjudication plea?
I have on both counts, yes.
All right, and Mr. Bustamante, you are charged with the first degree felony offense of aggravated assault of a dating, family, or household member with a weapon. A first degree felony does carry a range of punishment of not less than 5 years in prison or more than 99 years or life in prison should you be found guilty and convicted and sentenced. I see that there is a plea agreement in your case, and it appears to be that the DA's office is recommending that the court review the evidence and find that there is enough evidence to convict you, but they're recommending that the court not convict you today, rather to place you on 5 years of community supervision with a $100 family violence fine. In addition, you would have court costs of $290, reimbursement fees of $605, and the DA's office would be dismissing under section 1245 cause numbers CR 21-9, which is an aggravated assault with a deadly weapon, unfiled case DA 2020-1175, which is a criminal mischief, and as conditions of community supervision that you would be placed on the mental health caseload within the probation department, and that you would also be executing a protective order that will be good for the duration of the lifetime of, I believe, either you or the alleged victim in this case. Is that your understanding of the plea agreement?
Yes, sir, I understand completely.
Okay. All right. And so understanding the plea agreement, understanding the range of punishment, Mr. Bustamante, how do you plead to aggravated assault of a dating, family, or household member with a weapon?
Plead guilty, sir.
And are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir. That's
And
correct.
Mr. Bustamante, has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt at this time. Mr. Schmidt, do you have any objections to the stipulation of evidence?
I do not, Judge. If I could briefly, 1 second,
Yes, sir.
confer with Mr. Bustamante. Step over. No objection, Judge.
All right, and the court does take judicial notice of Mr. Bustamante's judicial confession. Is there anything further from the state?
Your Honor, just that the state is in compliance, victim impact statement was sent out. It wasn't returned, but we've been in continuous contact with, victim in this case. And he is supportive of this plea, with the protective order, as part of the agreement. And then, Your Honor, just as kind of a, clerical note, state would ask that Dr. Ingram be released from his subpoena for Thursday's hearing, as it won't be necessary anymore.
Okay. Anything further from the defense?
Yes, sir. Well, no, sir. I understand the nature of the plea bargain. I presume that we're going to conclude the plea and then take up the protective order.
Okay.
As a different cause number.
Correct, but the defendant is agreeing to it?
Yes, sir.
Okay, excellent. Okay, right, then, the court is going to consider the evidence at this time. Mr. Schmidt, I do not have a stipulation of evidence. Would you mind
Yes, sir. 1 moment, please.
displaying that for me? Or Mr. Hartwell, if you want to read it, I would do it.
Got it here, Judge.
Let's see if we can distinct the focus. Back up just a little bit, a little more. There we go, right there. All right, thank you, sir. All right, the court, having reviewed the evidence, finds sufficient evidence to convict the defendant. The court will follow the recommendation of the DA's office and the plea agreement between the parties. The court hereby defers a finding of guilt on the first-degree felony offense of aggravated assault of a family member with a weapon. The court defers a finding of guilt, places the defendant on 5 years community supervision, orders him to pay a $100 family violence fine, $290 in court costs, $605 in reimbursement fees. Court dismisses under section 1245, filed cause number CR 21-9, aggravated assault with a deadly weapon, unfiled cause DA 2020-1175, criminal mischief. Court orders Mr. Bustamante to be placed on the mental health caseload. And court finds that Mr. Bustamante is agreeing to a lifetime protective order for the protection of the applicant James Salcido Bustamante and other protected persons Sally Bustamante. All right, so Mr. Bustamante, you're hereby remanded to the custody of the probation department so that they can carry out the terms and conditions of the sentence. The court is going to adjourn in cause number CR 21281. Court now calls civil number FM 24-00398. This is in a matter of the application for a protective order. Go ahead, Mr. Schmidt.
Judge, I briefly called Mr. Bustamante and normally we would sign an agreed order to this effect. However, I don't have a signature page for the last page of the order on my person, so I'll just ask him real quick.
Okay.
I think he's already been sworn on the previous.
Yes, go ahead.
Mr. Bustamante, we discussed that your father and your stepmother has requested a lifetime protective order. And you understand what that is. And we went over that protective order that basically restricts your access to them. You can't go more than 500 yards of their residence or their person. You understand that? Okay. Now, you understand that that is in conjunction with your probation that we just finished right now. And you don't object to the entry of that protective order. Is that correct?
No, I do not object.
Okay. Passed away.
Any questions from the state?
No questions, Your Honor. Thank you.
All right. All right, the court finds that there being no objection to a protective order, it calls number FM 24398. The court hereby grants the protective order, finds that family violence did occur, and the court orders that Mr. James Daniel Bustamante be prohibited from the acts and limitations as provided in the protective order, and the court will sign that today. Anything further, Mr. Smith?
No, sir, nothing further.
Anything further on this, Mr. Hartwell?
Nothing further, Your Honor. Thank you.
All right, then Mr. Bustamante, if you will step over to be fingerprinted, then the probation officers will give you more information about what's next. Who would you like next, Mr. Smith?
Edward Drummond.
Mr. Drummond, cause number CR 24-50, State versus Edward Joseph Drummond. And are we doing a plea today, Mr. Smith?
Yes, sir, we are.
Mr. Drummond, sir, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you speak up loudly and clearly.
Yes,
You
sir.
can lower your hand. You can go ahead and put your hand down. All right, this is cause number CR 2450. Your name is Edward Joseph Drummond, correct?
Yes, sir.
And Mr. Drummond, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney and the work he's done?
Yes, sir.
Do you have any questions for him, the court, or about anything else that's going on in your plea agreement?
No, sir.
Mr. Schmidt, do you believe Mr. Drummond to be competent? And if so, have you explained to him his rights as they pertain to this case?
Judge, as far as competency is concerned, I would let the court know that we've had issues in the past with competency. Mr. Drummond has been recently treated by Terrell State Hospital and released to the custody here. I've met with him quite a few times over the last couple of years. And he has gone through periods where I would have argued that he was incompetent. As of today and within the last 30 days, I've been able to communicate with him. He's clear-headed, and I do believe he is competent. In addition, I have explained to him his rights as it pertains to this plea.
Thank you, Mr. Drummond. All right, Mr. Drummond, you are charged by indictment with the third-degree felony offense of engaging in organized criminal activity. I see that there's a plea agreement that the state's recommending to the court, and that is for a lesser charge of burglary of a building, a state jail felony. And their recommendation is that upon reviewing the evidence to convict you of that offense and then assess your punishment at 8 months confinement in the state jail, ordering you to pay a $1,000 fine, restitution of $115, court costs of $290, reimbursement fees of $35, and they are agreeing to dispose of 2 cases of burglary of a building and an unauthorized use of a vehicle. Both of those cases have not been filed and have not been filed in court. And you would also receive the time that you've already spent in jail towards your sentence, which would be 127 days. Is that your understanding of the plea?
Yes, sir.
All right. All right, then, Mr. Drummond, I've explained the plea agreement. I've explained the range of punishment. Well, actually, I don't know if I have explained the range of punishment. The range of punishment for a state jail felony is not less than 6 months in prison and no more than 2 years, and a fine not to exceed $10,000. Okay, so I see that the proposed plea agreement does fit lawfully within the legal range of punishment. Mr. Drummond, how do you plead to burglary of a building?
Guilty.
And are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
And Mr. Drummond, has anybody threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, thank you, Mr. Drummond. The court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection, Judge.
All right, the stipulation of evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Yes, sir. I would announce to the court that I've informed Mr. Drummond that the state is retaining a misdemeanor interference with a railroad case that I expect to be or has already been filed in the county court of law. We've already reached an agreement on that. We will resolve that in Judge Winter's court in November. So he is aware of that, and I want to make the court aware of that as well.
All right, thank you, Mr. Schmidt. I do appreciate that. And I do not see I do not see a stipulation of evidence in my pack here. Back up just a little bit so it'll focus a little more. It's not coming into focus. I can make do with that. Let's see. All right, thank you, Mr. Schmidt. All right, the court, having reviewed the evidence, finds that there is sufficient evidence to convict the defendant. The court will follow the plea agreement recommendation of the DA's office. The court hereby convicts Edward Joseph Drummond of the offense of burglary of a building, a state jail felony. Court assesses punishment at 8 months confinement in the state jail division of TDC, orders him to pay a $1,000 fine, $115 restitution, $290 court costs, $35 in reimbursement fees. The court does dismiss under section 1245 burglary of a building, DA 2023-906, DA 2024-809, unauthorized use of a vehicle. And the court awards Mr. Drummond 127 days credit towards his sentence for the time that he has spent in jail. Mr. Drummond, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted with the bailiff. But listen, once you get out of TDC and state jail, you need to know that if you have not already paid off your fines, court costs, and those things, you need to come up to the courthouse and make arrangements to pay those off. Otherwise, a warrant will most likely issue for you later in time, okay? And we don't want you to be coming in and out of the jail. So come up to the courthouse and set up a payment plan, and we'll get that paid off, okay?
Yes, sir.
All right, go ahead and step over to be fingerprinted.
What's our next docket?
Well, next week we have a trial. So,
Who would you like next?
Is Jordan Manning?
Jordan Andrew Manning, cause number CR 24-215, set for arraignment. Mr. Schmidt, do you need the indictment?
No, sir, we don't need the Judge, his name is spelled correctly. We understand the charges. Waive formal reading. As of today, we'll enter a plea of not guilty. Ask for the very next setting available. I think we have a resolution. I can't be here on Thursday afternoon, but the very next one after that.
And I'm sorry, you paused out for just a second. What did you say on the dates?
I said I can't be available Thursday afternoon, but the very next one that the court has available.
Okay. Will that be for pretrial or a plea, or what would that be for?
It's going to be for a plea.
For a plea? Very next one I would have would be Tuesday, November 12th. And would that be a plea would that be a morning plea or afternoon plea?
Morning, please, sir. But he'll likely be in custody, so we'll have to take care of it here at 1:30.
Okay, well, I was going to question you on that. So he would be in custody on other holds, or would he be needing to be released on a bond and then having to come to court?
If you would prefer to have him at court in the morning to resolve his plea, then he would have to be released on a bond. I think this is Van Zandt's the only one who's holding him.
Okay, and so just go ahead and tell me what is he going to be pleading to? Just
For deferred.
for deferred.
Yes, sir.
And since I'm assuming we can't do that today, correct?
No, sir.
State, do you have a position on Mr. Manning?
Your Honor, given that we are offering probation in this case, state would be unopposed to a bond. Either severe reduction or personal.
Does he have any ability to post a bond, Mr.?
No, sir, he does not.
Okay. All right, then, what we'll do for you, Mr. Manning, is rather than hold you over for a couple of weeks in jail, I will grant you a personal bond today. I'm gonna order you back to this court on November 12th. That's a Tuesday. In 2 weeks, about a week and a half, and you can do your plea on that day.
Yes,
Okay.
sir.
So, Mr. Manning, let me caution you, okay? I want you to pay attention.
Yes, sir.
100% here, okay? So I'm gonna let you out of jail. If you go and you screw up on conditions of pretrial release, you commit another offense, or you don't show up to court, you will not be getting that deal. I don't care what the DA's office says. I don't care what Mr. Schmidt says. If you can't follow the rules and show up when you're supposed to and do what you're supposed to, there's no way you'll be able to make probation. So I'm kind of writing you a check here, and it's gonna be yours to cash. You're either gonna forfeit it or you're gonna cash it on November 12th. Are we clear with each other?
Yes, sir.
Okay. So, Mr. Schmidt, I will get an order signed. Once Ms. Tabraham gets back over here, I'll get that signed and we'll get it sent out there. So it won't be immediate, but it'll be sometime this afternoon.
Thank you, sir.
You're welcome.
It's Corey Fullbright.
Fullbright, this is cause numbers CR 24-133, CR 22-214, CR 23-138, and CR 23-139, State versus Corey and Gerard Fullbright, and it looks like we are docket call on all cases. Go ahead, Mr.
That's correct, Judge. I have conferred with Mr. Fullbright in detail on these matters. At this point in time, we will announce ready for trial on all causes.
Okay. And Mr. Schmidt, can you tell me if any offer's been made by the state, and if so, what it is, so that I can have that of record?
Yes, sir. The state has tendered an offer for 9 years TDCJ.
All right. Court will place Mr. Fullbright on the court's jury selection docket. We will begin, he'll enter the docket, Mr. Schmidt, on Monday, November 4th. And looking at the charges, I'm sure that Ms. Tabraham and I will be setting this for a special setting.
Yes, sir.
We'll send both you and the state notice of that, but we'll go ahead and place it on the docket beginning November 4th.
Thank you, sir. Michael Powell.
All right, this is cause number CR 24-146, State versus Michael Ray Powell Jr. for arraignment. Go ahead, Mr. Schmidt.
Judge, we understand the charges, name spelled correctly, wait for reading and plea not guilty. As for a pretrial setting, I believe we will likely resolve this case pretty quickly. If we could have that November 12th date, we may be prepared to plead that day.
Okay. Court finds that Mr. Powell has waived the formal requirements of arraignment. Court does enter his plea of not guilty in the record, and the court will set this for a pretrial matter on November 12th at 1:30.
Yeah. Thank you. Yeah. Dallas Hightower.
This is cause number CR 23-217, State versus Dallas, Justin Hightower. Is this a plea today, Mr. Schmidt?
It is not, Judge. It's an announcement. I've been working with the state and the probation department. I think all parties are in agreement that Mr. Hightower is in need of inpatient rehabilitation services. I do not believe, based on my conversations with Ms. Burns, that Safe P is an option. So we were trying to find a viable alternative so that he can remain on community supervision, but get drug rehabilitation treatment. So we'd ask for a reset. I don't know, 30 days. Hopefully we could find something that.
All right. Any objection from the state?
No objection, Your Honor. Thank you.
All right, then the court sets Mr. Hightower for, you want a pretrial setting, Mr. Schmidt?
Judge, this is a motion to adjudicate, so however the court wants to label it is fine.
You want to set it on the docket November 26th? And then.
Yeah, sir. That should be sufficient.
All right, court sets Mr. Hightower for November 26th, 1:30.
It's Thanksgiving. We haven't court on Thanksgiving. Is Thanksgiving the 26th, Judge?
No, it's the 28th.
Oh, I see.
Pretty close though.
Only one. Which one are you talking about? Probably another one. This is Jacob Paul.
Jacob Thomas Hall, CR 24-136 for docket call. Go ahead, Mr. Schmidt.
Judge, at this point, we're in negotiation with the state. I think we're fairly close to a resolution. We'd ask for an additional docket call. I think me and Mr. Hartwell have some logistical matters to work out, but by and large, we have, I think, the framework of the plea agreement.
Think that's something you could get done by November 12th?
Yes, sir. I think it is.
All right, court sets Mr. Hall then. You want docket call?
Yes, sir, please.
Court sets docket call November 12th at 1:30.
Hey, Banda, can they put Drummond back? Drummond? Yeah. Steven, step on Pickron.
For Pickle. All right, here we go. Cause number CR 24-28, State versus Stephen Arkell Pickron for pretrial. Go ahead.
Judge, I don't have any contested motions that need hearing at this point. We'd ask for docket call setting.
All right, court finding there are no contested pretrial motions. Court sets Mr. Pickron for docket call December 3rd at 1:30.
Need about 3 minutes to organize my stack, if you don't mind, Judge.
Is that a Judge Martin 3 minutes or is that a Richard Smith 3 minutes?
I think it's a hybrid.
Hybrid? Okay, I'll see you in 10.
Thank you.
All right. Your Honor,
Yes.
I sent you a message and then we're ready.
All right, Mr. Schmidt, give me just 1 minute, okay?
Yes, sir.
Can't say anything.
Well, I could say something, but there's a limit to, what is it, sarcasm? I can't say it.
We're doing good to even get to pay much less stuff.
Closer to custody.
I know, I didn't even get a paycheck. I didn't even get a paycheck on Friday till about noon. Something about they did deposits. They usually send them on Wednesday. They didn't send the wires, the transfer till Thursday afternoon. Cause I haven't seen mine.
You know, those payroll accounts are interest bearing, so if they get one more day with deposits, they give them interest.
All right, Mr. Schmidt, who are you ready?
Jason McDonald.
Mr. McDonald, sir, if you'll come up. This is cause number CR 23-151, State versus Jason Wayne McDonald, docket call. Go ahead, Mr. Schmidt.
Judge, part of our docket call was a status on a new alleged offense. I did meet with Mr. Hartwell last week on Mr. McDonald's case, and we are investigating the new allegations, but as of today, we don't quite have an answer, so we'd ask for an additional docket call setting.
Any objection from the state?
No objection, Your Honor. Thank you.
All right, court sets additional docket call December 3rd at 1:30.
Your Honor,
No.
no, I was just gonna make a request.
No, you can step back here and tell me what you want.
Do you have his request addressed, Mr. Schmidt?
Yes, sir.
Okay. All right, Mr. McDonald, we'll see you back December 3rd.
Sound like it. Michael Williams.
Michael Scott Williams, CR 21-200, CR 24-193. Motion to revoke and pretrial. Go ahead, Mr. Schmidt.
Judge, on the pretrial case, we have no contested motions in need of setting at this point. We'd ask for a docket call setting on that case and ask to carry the motion to adjudicate with it.
All right, court finds no contested pretrial motions requested to be heard. Court sets Mr. Williams for docket call on December 3rd and will carry the motion to revoke even date.
Cindy Smith, come on down.
All right, this is cause number CR 21-190, State versus Cindy Marie Smith for arraignment. Go ahead.
Judge, Ms. Smith's name is laid out correctly. She understands the nature of the charges. We would waive formal reading of the indictment and enter a plea of not guilty, ask for a pretrial setting.
All right, the court enters Ms. Smith's plea of not guilty into the record, finds that she's waived the formal requirements of arraignment. The court sets this matter for pretrial hearing December 3rd at 1:30.
Amber Braxton.
Amber Elizabeth Craxton, CR 23-182 and 183. Pretrial in each case. Go ahead.
No contested motions to be heard at this time. Judge, ask for docket call setting.
All right, there being no contested pretrial motions, court sets docket call December 3rd, each case at 1:30.
December 3rd. I was at Walmart. I'm pretty sure December 3rd is Christmas. It's gotta be. I believe that's all mine.
Mr. Schmidt, you are a very efficient attorney.
Thank you, sir. Try to.
Thank you for your work today. All right, Ms. Tabraham, who would you like to have first? I have Mr. Weiner on Zoom. And then I guess we also have Ms. Rollins.
Oh, Your Honor. Just give her 1 second. She went to go talk to Miss the booking.
Okay, sounds good.
Yes, sir.
Judge, on Miss Rollins, I'm not sure that you really need to see her. There's no MTR filed or anything. She just agreed on her own to go to safety, so we amended.
Okay, did you have already seen that and signed that?
No, I'm bringing it to you.
Okay,
I had to get her to sign.
okay, that's fine. Then we don't need to bring Ms. Rollins up.
I guess she came. Huh? She never came. Oh, she didn't.
Is she not here? She didn't appear at the jail?
You haven't booked her in. Not to my, not
Not
to
to our knowledge.
our knowledge. Oh, I thought they were getting, that's what I thought.
Yeah, that's what I think.
So do we need to have her name called over there at the jail and then back here at the courthouse?
Let me go verify with Lieutenant.
Well, let me ask, Karen, is she on a motion to adjudicate?
No,
Or
sir. She just agreed with Officer Matura to go to safety. So, Officer Matura amended her conditions of probation and she signed them in her office. She was supposed to turn herself in today at 1:30.
Okay, so you'll have to make a determination if you want to allow her to still take advantage of that at another date, or if you're gonna have to file a motion. Since she's not on bond, there wouldn't be anything for the court to do.
Correct.
So do we have Miss Warington? Is she in there?
Yes, sir.
Yeah. Go ahead and bring Miss Warington up and I'll bring Mr. Weiner in. He's online. All right, Miss Warington, give me just 1 second. Don't say anything. Let your attorney, Mr. Weiner, get in here and then we'll get going, okay?
Oh, I made it. Hey, Judge.
Good afternoon, Mr. Weiner. How are you doing, sir?
Hey, I'm good. How about yourself?
I am doing great. I appreciate you asking. All right, I've got Miss Warington here in the Van Zandt County Justice Center. This is cause number CR 24-38, State versus Cynthia Joyce Warington. I believe we're on docket call. Go ahead, Mr. Weiner.
We are, Judge. I recently subbed in on this case. I believe you signed the motion or the order rather to sub in 2 weeks ago. I've met with my client. I have the paper discovery. It looks like there's about 9 body cameras I need to pick up. The DA's office wants me to drop off a jump drive. I just haven't been in your neck of the woods in the last week and a half to do that. So I plan on getting that done hopefully next week so I can pick up the video discovery and then raise any potential pretrial issues if necessary, Judge.
You think we could do December 3rd or December 5th?
Let me take a look at my calendar. I appreciate the options. I could do December 3rd at 1:30. That'd be great, Judge.
Okay. All right. Court will set Miss Warington then for docket call. Oh, actually, yeah. Well, let's go back. We'll do pre-trial. That way you'll have a chance to look at the discovery on December 3rd at 1:30.
Thank you so much, Judge. And Cynthia, I'll be in touch with you, okay?
Thank you.
Thank you, Ms. Bonner. Good to see you.
Hey, and as always, I know I say it, but I really appreciate the ability to come via Zoom and save some drive time. So thank you very much.
Hey, you're welcome. Tell the voters.
I will.
Have a good
Bye.
night. All right, Ms. Tabraham, is there anyone that we're lacking other than our extradition?
Well, we're still trying to figure out Rollins. I should have that answer in just a minute.
All right, well, let's wait. Then that'll give me an opportunity to review the paperwork for Mr. Nunez.
Okay. Your Honor.
Yes.
Okay, Miss Rollins is here. We have put our eyes on her.
Okay, good.
Deputy Banda is going to do the booking sheet and she will be booked in.
Okay, and so she's already signed her amendment, is what Karen said.
Yes, Your Honor.
Okay, so she's good to go then, and we don't need to bring her up.
Yes, sir.
Okay.
So we're ready on the extradition when you are.
Does Carlos need to go over the paperwork with him?
Yes.
No, no, he has.
He has already? Okay. All right, then that's gonna conclude our criminal docket. The court's going to recess and then